The Dakota Proclamation by Meredith Quinn, Musa. Indian Sovereignty versus U.S. Citizenship. Part 2. So, there is no act or law for the Indian to present his side of the case, or prove the court has no jurisdiction, because remember that you are in foreign country while in the courtroom. The only reason he can do anything in court is because of the person's ignorance. Now, this judge is going to do everything he knows to sentence you with due process, because the longer you're there, the greater chance there is that you may uncover the fact that he brought you to this courtroom illegally. So, when this judge states the question of jurisdiction will not be brought into court procedures, have a prepared statement of exclusive jurisdiction. Make it state that citizens and members of Indian tribes cannot assume to have obligations to or under the protection of a nation other than their own, because U.S. citizenship and Indian exclusive control are in conflict due to Indian sovereign land-based rights. The court has no right to assume this jurisdiction when it cannot prove that any existing tribal relations or affiliations have terminated or dissolved because of you having left Indian sovereign territories. This question of jurisdiction, or the lack of it, is the exclusive right of Congress, which cannot be set aside, changed, or altered as long as the Indian has not asked that guardianship, alienation, and severalty be relieved. Then quote U.S. Halbert versus U.S. Washington, etc., etc. Next, state that the question of jurisdiction to trial on this charge is questionable because the courts of this country have never been open to Indians, and your civil liberty has never been given to us. Jaeger versus U.S. Second, you just can't, as an Indian, present an enrollment number to the court to prove that you are a citizen of your Indian nation. The burden of proof is on the judge to prove that you are a legal citizen of the United States. The acts are very defined as to procedures. The judge must prove that you have a 1. Certificate of tribal abandonment, 2. Certificate of competency, 3. Certificate of eligibility, 4. That the Secretary of the Interior holds a land title that you purchased land to be held in trust for 25 years, after which Congress will pass a bill making you free of guardianship, alienation, and severalty. 3. A certificate of citizenship issued by the Secretary of the Interior. While the judge is crawling the walls, tell him to prove that the Citizenship Acts for the Indians or for Indians not born on the dates that the acts passed the U.S. Congress, i.e. 1924. Then quote Totus versus U.S. If the judge thinks you're not going to let him come off the walls and moves to disregard all this information, tell him that you are invoking ex parte crow dog and that you must contact a United States District Attorney to arrange for the judge's personal arrest. Should he refuse to let you leave the courtroom, find some way to contact me. I'll do the job, no problems. Everybody's in the wrong country. So, fellow Indians, you have no choice but to fight in the only legal area that is open to us, Indian sovereignty. We must learn and understand what our duties, rights, and responsibilities are as members of independent nations, according to the international code that every nation in the civilized world goes by. We must understand it well enough so that the white man will not get us fighting amongst ourselves, saying, no two Indian reservations are alike. I'm not saying he's going to let us get away with it. I can't forget his greed and our ignorance. Besides, There's a long-established record he has built telling the people of this nation what the Indian problem is. We have to overcome the idea attorneys licensed with any of the state bars in the United States can help us, because they can't. They hope we remain in ignorance so they can establish a great name for themselves as Indian crusaders. Their ego has helped the government take absolute control over us. The other day I was teaching an attorney how to prove that the Indian was not a legal citizen. This was an attorney heavily involved in Indian rights. Few Indians know that you can bring suit against attorneys that have given wrong information that has cost millions of dollars in loss of Indian land rights. Besides, any attorney cannot legally represent the Indian in a court of law. He is an attorney from a foreign country, foreign to ours. No court in the American judicial system can fairly pass judgment on Indian problems because they are not the courtrooms of the Indian. The U.S. courtroom is in a foreign land. You have no business there. The court history will read as follows. When injury of occupancy occurs, the Indian should seek relief from Congress and not the courts. If you permit attorneys to take your sovereign rights to another country's courtroom, how can you expect not to lose your lands, water, and resources? The U.S. government will always protect itself in international courts because if someday the Indian should come out in fullness, the government can still say, he tried to teach law to the Indian on his legal nation, but he always was running to the domestic courts of the United States, something the Indian should have never done. This was what he wanted to do. The Indian was giving his lands away, and we, U.S., tried to stop it. You don't think that the white man is going to have anyone say that he was never fair, do you? You don't think that the white man is going to have any nation in the world say, he's not pure, white, self-righteous, and would dirty his hands on yellow, brown, red, or black people, do you? Why do you think he has toilets that flush? To make people believe his shit doesn't stink. If we are sovereign nations, and because of ignorance we are unable to present to the world our sovereignty for help, how do we expect to get help from other nations if we have no airports for them to land, no bus lines to get them there, no Army, Navy, or Air Force to offer protection, no trains, no health department, no police, no courts, no laws, no schools, no nothing? What is really ironic is we won 1,000 wars and didn't know that you are supposed to destroy the culture and language of the defeated, according to European law. They should, if they were civilized, bring gifts and lay them at our feet. No, we are his slaves, guinea pigs, something to kill for sport. While everybody gets Indians to debate as to whether he is a citizen or not, or even as to whether he is a citizen of his own sovereign nation, a select few men in the world can continue genocide programs on the Indian in both North and South America. Keep the Indians ignorant. Other peoples need his valuable experience to help find out how to fight and stay alive. Even the government, enjoying the confusion, moves legal acts to suit these special interest groups so as to offer protection and a loophole to back out in case of jurisdiction questions. But to confront the Indian's ignorance, let's review how this confusion works against him. 18 U.S.C.A. 1152, Cauliflower versus Garland, 342, F. 2nd, 369. C.A. Mont, 1963, Sovereignty bars way of one wishing to sue Indian tribes. Cherokee Nation versus Southern Kansas Railway Company. An Indian tribe is not a sovereign nation, and the United States may exercise the power of eminent domain in its territory. This act started the railroads across the country. In this area, Indians gave only permission. When these railroads stop running, they must go back to the Indian, including the lands. All dams built in this country are Indians. The Indian gave territory to have water delivered to their reservation. To date, this contract has never been fulfilled. If the contract has expired and there is still no water, the dams automatically belong to the Indians. 58 SCT 331, certiorari granted U.S. versus Shoshone of Wind River Reservation, Wyoming. The title of the government to Indian lands, which has been designated as a naked fee, is a sovereign title, the government having no landlord from whom it holds the fee. U.S. versus Salamanca. This section expressly accepts from its provisions treaties therefore made, otherwise the United States could abolish or change a treaty without approval of the tribe with whom it was made. The power of an Indian sovereign nation is here. It clearly states that the government accepts the treaties made, and the otherwise applies only if attorneys who are not licensed to represent the Indian nations accept from Indians the right to present Indian problems in a court of law, foreign to that of the Indians. Because of the Indians' ignorance, this statute and court history, which gives Indian sovereignty, could be changed and have restrictions because of attorneys' limited ability to state laws that protect the Indians. Attorneys of the legal bar system of the United States are not international lawyers. 42 CJS 24. The United States has power to make treaties with Indian tribes. When did Indians give this power to them? The Indian has the right to treat it as a nation or states in a limited sense, dependent, it is true, but still capable of making treaties, only because the government is the guardian of the Indian. And should the Indian ask for this back, this treaty made with Indians without their permission could be called illegal. And the number of treaties were made in reference to lands, supplies, education, and other matters. This method of dealing with the Indian tribes by treaty was abrogated, abolished, however, by the Act of March 3, 1871, which provided that no Indian nation or tribe within the territory of the United States should be acknowledged or recognized as an independent nation, tribe, or power, with further provided that no obligation of any treaty law fully made and ratified with any such Indian nation or tribe prior to the date of the act should be thereby invalidated, to weaken or destroy or impaired, to make worse. Here again is the power of Indian sovereignty at work. Whatever the system used by the U.S. government to empower themselves to have the right to make treaties can only come from the guardianship jurisdiction of the government. But this limited legal concept comes from the Indian not knowing that the government is doing this. But still, there is the question of permitting attorneys to represent the Indian and his problem in a court of law that has never been opened to him. The Indian must regain his sovereignty and correct the mistakes of the white man. Otherwise, there will be a complete breakdown of all entities in the world through international law. I believe Earl Shorus, in his book, Death of the Great Spirit, I have been accused of being this person, by sellout Indians, gave a concept, and it went something like this. The Indian must suffer because he lies too close to the foundations of the government. As members of the Dakota nations, we must find ways to remind the nations of the world of an important fact. Wounded Knee was not a battle, and the incidents that it involved have never been told correctly by historians or educators. It's not part of American Indian or American history. So this period of time cannot be reviewed or debated till it has been straightened out, Here are some of the facts. Of the battles the Dakota Sioux nations won, which are a little over 100, the Sioux never tried to command the white man to live by a new set of rules mandated by the conqueror. They were permitted to continue in their lifestyle, but were asked to please leave Dakota and his territory alone and to try and amend their ways. It was a brand new concept that the civilized world had never heard of. It is the practice of civilized right and ethics of a European nation to oppress the people of conquered or ceded territories, to rob, rape, and plunder the civilization, so that the new idea would have no conflicts. A strange people who had already made the statement, "Man is born free," which helped spark the French Revolution, freeing the common man from the absolute rule of royalty, now presented a new concept, proving that he was not only the master of battle, but the master of peace. His act fulfilled the highest level of the white man's dream, philosophies, and religions. This proof cannot be questioned. His everyday code of ethics were rules the rest of the civilized nations had not yet found a way to incorporate into their societies, which still holds today. The world demanded to see this strange human being who broke all rules of civilized concept and brought back the God state of manhood. So Wild West shows were formed to go around the world. Buffalo Bill Cody was one of the leaders to help the Sioux present this idea because of his love for these people. While the strength of the Dakota nations toured Europe, back to the Dakota territories, men were putting together Wounded Knee. And when this great civilized act took place and latter became forgotten history, the reason for Wounded Knee was omitted. Buffalo Bill Cody rushed the Dakota nation back, but it was too late. There was no way he could help. And as he watched the smoke coming from Wounded Knee, he stood crying like a baby next to Indian Superintendent Laughlin. Buffalo Bill knew he had been an instrument to an act the government of the United States could never reveal to the rest of the civilized world. Yes, the Dakota nations had trusted this white man. While members of the Manifest Destiny counted very much on this fact, they created the act that would continue the idea that civilization belonged to only people of European descent, and not to all, as the Indian believed. Read it. It's part of the old records of the West. Study the law history of the Cherokee Nation, and you will see this international law really works. The nation of the Cherokee was lost under the same concept that the Hopis encountered when they took Black Mesa to the Supreme Court. The court system was of a nation foreign to theirs. All the laws written between the U.S. and Indian nations are complete enough to where the Indian can dictate policy to the government of the United States. Only the lack of this knowledge by the Indian prevents this. If you ask another nation to give you an opinion on what to do, this nation will always use a point of reference that will protect him. It's common sense. The United States government even bent over backwards to let the Indians know they have the right to make policy. Read the treaty as of March 15th, 1785, Article 12. That the Indians may have full confidence in the justice of the United States respecting their interests. They shall have the right to send a deputy of their choice whenever they think fit to Congress. So, when this Indian nation went to another nation for an opinion, naturally, the opinion was in the favor of the other nation. Common sense. The Indian had assumed that he was a citizen of that other nation, and so the thought he had the rights to these courts, so they passed an act. State of Georgia, 1829 General Assembly versus Karnak and Ragland, 1830. Let's read Section 7. And be it further enacted that after the first day of June next, and be it further enacted that after the first day of June next, all laws, ordinances, orders, and regulations of any kind whatever made, passed, or enacted by the Cherokee Indians, either in general council or in any other way whatever, or by any authority whatever of said tribe, be and the same are hereby declared to be null and void and of no effect, as if the same had never existed. And in all cases of indictment or civil suits, it shall not be lawful for the defendant to justify under any of said laws, ordinances, orders, or regulations, nor shall the courts of this state permit the same to be given in evidence on the trial of any suit whatever. If the Indian is a citizen of the United States, why did they write this? The Cherokee Nation lost those lands because they assumed they were citizens of another nation. Such an act could never have been written for a person or a citizen of the United States. It was written to break the rights of a nation, the Indian nation. It was dealing with a land right different than the land rights that belong to citizens of the United States. Now, because these Cherokees believed they were citizens of the United States, it was stated a year or so later that the Cherokee Nation alleged was repugnant to the constitutional laws and treaties of the United States. They were again brought before the Supreme Court, and Chief Justice Marshall gave the decision for the state of Georgia to seize the whole Cherokee Nation, which they did, and parcel it out to the counties. It thereby abolished the Indian nation's institutions, laws, and annihilated their political existence. These acts broke every law that governs all white races wherever they are in the world, and it had to be corrected. So they had to find land quick and replace the nation that was destroyed, that it had no right to touch, all because this nation had asked to become part of the United States. That's right. The Cherokees had asked to become citizens and their territory to be part of the United States. This is what happens to a people that are conquerors and they don't know it. So the United States found the territory it had no right to and declared it a new land for the Cherokee Nation. This is what they declared. Congress, first session, the Indian Department, to provide for the establishment of the Western Territory and for the security and protection of the emigrant and other Indian tribes therein. Whatever difference of the government may heretofore have existed, the policy of the government in regard to the future condition of these tribes of Indians may now be regarded as definitively settled. To induce them to move west of the Mississippi to a territory set apart and dedicated to their use and government forever, to secure to them there a final home, to elevate their intellectual, moral, and civil condition, and to fit them for the enjoyment of the blessing of a free government, is that policy. And a further hope is now encouraged that whenever their advance in civilization should warrant, as a state, to become a member of the Union. This was later identified as the territory of Oklahoma. A new territory had been found for the Indians that had their land openly stolen, and now the right to evict had its writ. Men, women, old people, and children marched from the territories of Georgia to the Oklahoma Territory. This incident is often referred to as the Trail of Tears. This march costed millions of Indian lives because where they fell was their grave. They marched without food, water, or rest. A people that asked to become citizens of the United States now were being given their reward, European style. The same incident against the Indian was later to invoke a promise from the religious leaders of this Indian nation. For this march, forced upon my people, in which there is much suffering It has killed the babies first, and the mothers from sorrow. For this too, you too shall march, the march of death, and you shall eat your children yet to be born. The people of the Deep South had not forgotten this promise, and when World War II told of the Bataan Death March, they remembered, for when the Indians spoke, it came to pass. But meanwhile, at universities and colleges, professors and scholars and I are going round and round. I state that 23 million Indian lives and 190 million acres of land were lost under the presidency of Jackson, and that President Thomas Jefferson got 100 million acres of land, along with 46 million Indian lives. They're calling me a liar and fake the whole trip. They insist that President Jackson on his term only murdered 17 million Indian lives, and President Jefferson only 37 million lives. We are in a disagreement over 15 million Indian lives, and it looks like they're not going to give any ground. So I concede. These professors and scholars have credentials, so they've got to be right. Getting back to the territory of Oklahoma, it was to come into the Union of the United States as an Indian state. It didn't. It came as a white state. The most court decisions of court history on the Indian not being a citizen of the U.S. come from this nation of Indians. The territories of the Black Hills, Everglades, and the states of Washington and Alaska are all illegal because of treaties with the Indians. Statehood acts have never been kept. Even California, because of ignorance, remains an illegal state of the Union. If the Indian understood his sovereign rights, he, and he only, could go out and occupy 270 million acres of land, create new nations. He could win this right according to international law.